So good morning everyone, or good day to which whatever time you are watching this video. So my name is Anna Rose Umambak, and my topic is still all about laws concerning marriage and family, and it's still under the chapter 3, and this is a continuation of Miss Miliumida's report. So I will discuss to you the article 45 until article 54. Okay. So for Article 45, it states that a marriage may be annulled for any of the following causes existing at the time of the marriage. So in this article, it talks about what are the grounds that you may be used to reason if you want to annul your marriage, especially if there are issues or grounds that exist after you married your significant other. So in paragraph number 1, it states that the party in whose behalf it is sought to have the marriage annulled was 18 years of age or over but below 21, and the marriage was solemnized without the consent of the parents, guardian, or person having substitute parental authority over the party, in that order unless, after attaining to the age of 21, such party freely cohabited with the other and both lived together as husband and wife. So in this paragraph, it states that the legality of your marriage. So if you age 18 years old to 21, you have to obtain a parental consent to make your marriage valid. But if ever you cannot obtain a parental consent, your marriage is still considered valid but voidable, because one party may file an annulment because of this ground, because you don't have the consent. And also, if you reach 21 years old and still you continue to live with that partner and you are not filing an annulment in your age of 21 years old, so meaning that you have accepted your marriage with your partner. So if ever you are 21 years old and still living with your partner, meaning you already accepted your marriage. So you cannot use this ground as a reason for annulment if you already reach the age beyond 21 years old, because it's just kanang claim that you accepted the marriage because you didn't file an annulment after you reach the 21 years old. Okay. So for the paragraph number 2, it states that either party was of unsound mind unless such party, after coming to reason, freely cohabited with the other as husband and wife. So in paragraph 2, it states that if you married a person and then you discover after marriage that the person you marry has or is mentally incapacitated and you didn't know it before your marriage. So this can be the reason or the ground that you can use for annulling your marriage. So if ever that you have already know the fact that your partner is of unsound mind or mentally incapacitated and still you continue to live with your partner even despite the fact of knowing that he is mentally incapacitated, you are accepting already your marriage with that person. So you cannot use this ground as a reason for annulment if you already know the fact that he is mentally incapacitated and still you continue to live with your partner. So in paragraph number 3, it states that the consent of either party was obtained by fraud unless such party afterwards, with full knowledge of the facts constituting the fraud, freely cohabited with the other as husband and wife. So this paragraph states that you can annul your marriage if you are into marriage nga na ay pagpangilad. So for example, sa mga lalaki nga nakabuntis kintahay, so pakaslan nila ang babae nga nabuntisan nila. So after the marriage, later na-discover sa lalaki nga ang gibuntis sa babae is dili day iyahang anak. So this situation or this could be a ground for annulment of their marriage. So if ever pod nga aware ang lalaki nga dili day niya anak ang gibuntis sa iyahang asawa and still he accepted and continued to live with that partner despite knowing that fact nga dili siya ang amahan sa bata. So meaning nga he accepted that situation, so he cannot use this ground for annulment once he know the fact and still continue with that partner. So for the paragraph number 4, that the consent of either party was obtained by force, intimidation, or undue influence, unless the same having disappeared or ceased, such party thereafter freely cohabited with the other as husband and wife. So this paragraph states that you can annul your marriage if you are being forced by it. So kanang na pugos lang ka nga magpakasal sa usa ka tawo. So the force also is, for example, kanang napugos lang kag pakasal sa usa ka tawo because gihadlo ka or gihulga ka nga maghikog siya if dili ka magpakasal niya. So that is also can be used as a ground for annulment of your marriage. And also if you already know this fact nga gi-force ka or gihulga ka sa imuhang pagpakasal and you still continue nga mupuyo kauban ang imuhang partner nga nangilad nimo, meaning nga you accepted your marriage and you cannot use this ground as for annulment because you already accepted man and you already know the fact nga giilad ra ka at the very first place. So you have a weak claim if you will use this ground. For the paragraph number 5, it states that either party was physically incapable of consummating the marriage with the other, and such incapacity continues and appears to be incurable, or that either party was afflicted with a sexually transmissible disease found to be serious and appears to be incurable. So 5 and 6 is kanang sumpay lang, no? So this paragraph states nga kanang if one of your partner cannot fulfill his responsibility to you, for especially for sexual intercourse, so you can use this as a ground for annulment, especially if he has a disability or a transmissible disease that cannot be cured. So this could be a reason or a ground to annul your marriage, because in a marriage, according to research, sex is a vital component of marriage, no? So if ever one of your partner cannot fulfill his or her responsibility to you in this field, so it could be used as a ground for annulment. Okay, so we are now in Article 46. So any of the following circumstances shall constitute fraud referred to in number 3 of the preceding article. So in Article 45, under the paragraph 3, we talk about the fraud, something fraud about in marriage. So in paragraph number 1 of this article, it states that non-disclosure of a previous conviction by final judgment of the other party of a crime involving moral turpitude. So in this paragraph, it states nga nailad ka sa imuhang marriage tungod kay abihan nimo nga disente maayong tao o innocente ang imuhang gipakaslan nga tao, but after marriage you discover nga naa siya kanang crimes or murder nga nabuhat sa iyahang kinabuhi, and then you just discovered it after your marriage. So this fraud or this type of fraud can be used as a ground for annulling your marriage. So for paragraph number 2, concealment by the wife of the fact that at the time of the marriage she was pregnant by a man other than her husband. So in this paragraph, it talks about that the man is being into marriage, that the wife is being pregnant with the other man. So with this situation, the husband can use this as a ground to annul his marriage to his wife. Okay. So for the paragraph number 3, concealment of sexually transmissible disease regardless of its nature existing at the time of the marriage. So if ever nakasal ka nga imuhang partner is gitapig-tapigan niya nga naa siya transmissible disease like HIV, and then you discovered it later after you married that person, so this could be a ground that you can use in annulling your marriage also. And for the paragraph number 4, it states that concealment of drug addiction, habitual alcoholism, or homosexuality or lesbianism existing at the time of the marriage. So if ever nga nakasal na ka sa imuhang partner and then you just discovered nga addict day siya or na palainom siya, so pwede na nimo siya mahimo nga ground if ever nga kani siya nga mga situation is present after sa imuhang marriage and wala ka kahibaw ani nga mga binuhatan sa imuhang partner before mo nagminyo. Now, let's proceed to the Article 47, which is the action for annulment of marriage must be filed by the following persons and within the periods indicated herein. So, in this article, it talks about who are the eligible people who can file the annulment. So, for paragraph number 1, for causes mentioned in number 1 of Article 45 by the party whose parent or guardian did not give his or her consent within 5 years after attaining the age of 21, or by the parent or guardian or person having legal charge of the minor at any time before such party has reached the age of 21. So for the paragraph 1 in the Article 45, so the eligible person that can file for the annulment is the parents of the person who is under the age of 18 to 21 years old, or also the guardian, or also the person who is in that marriage if he already reached the age of 21 years old. So once he reached the 21 years old, he or she can file the annulment within 5 years. But the parents can file the annulment even if his or her daughter is still under the age of 18 to 21. So for paragraph number 2, for causes mentioned in number 2 of Article 45 by the same spouse who had no knowledge of the other's insanity, or by any relative or guardian or person having legal charge of the insane at any time before the death of either party, or by the insane spouse during a lucid interval or after regaining sanity. So for this paragraph, the eligible person who can file the annulment is the spouse or the other spouse who had a stable mentality or mental health, and also the relative of the insane person. So the legal representative also can file annulment for the both parties if ever the both parties are in unstable mentality or is insane. So for paragraph number 3, for causes mentioned in number 3 of Article 45 by the injured party within 5 years after the discovery of the fraud. So for number 3 of Article 45 talks about the fraud. So the victim of the fraud may file the case for annulment within 5 years. So for paragraph number 4, for causes mentioned in number 4 of Article 45 by the injured party within 5 years from the time the force, intimidation, or undue influence disappeared or ceased. So for this paragraph, the person eligible to file the annulment is also the injured party or the victim of the force, the intimidation, and undue influence. So it is also can be filed within 5 years. And for the last, for causes mentioned in number 5 and 6 of Article 45, it is also can be filed by the injured party or the victim also for 5 years or within 5 years after marriage. Now, we are in Article 48. So in all cases of annulment or declaration of absolute nullity of marriage, the court shall order the prosecuting attorney or fiscal assigned to it to appear on behalf of the state, to take steps to prevent collusion between the parties, and to take care that evidence is not fabricated or suppressed. So in the Philippines, there is a prosecuting attorney that would represent the state. So in order nga walay fair or bias nga mahitabo sa judgment sa ilahang nullity sa ilahang marriage, and also to prevent collusion between the parties kanang walay agreement ang duha, and then walay mga documents nga fabricated. So now, in Article 49, during the pendency of the action and in the absence of adequate provision in a written agreement between the spouses, the court shall provide for the support of the spouses and the custody and support of their common children. The court shall give paramount consideration to the moral and material welfare of said children and their choice of the parent with whom they wish to remain as provided to in Title Number 9. It shall also provide for appropriate visitation rights of the other parents. So in this article, it talks about the rights of the children that is affected by the annulment of their parents. So it talks about the written agreement sa mga parents if ever walay nakastate dito og mga rights nga pwede madawat sa mga children. So the court ang mo introduce ana nga issue sa mga parents. So for the Article 50, the effects provided for by paragraphs 2, 3, 4, and 5 of Article 43 and by Article 44 shall also apply in the proper cases to marriages which are declared ab initio or annulled by final judgment under Articles 40 and 45. So Article 50 of the Family Code of the Philippines establishes that certain effects related to the dissolution of marriage also apply to marriages that are declared null and void from the beginning, or what we call the ab initio, or annulled through a final judgment. So this article emphasizes the legal consequences that arise from annulment and the declaration of nullity. So when a marriage is annulled or declared void, the community property or conjugal partnership is dissolved or divided. But if one spouse acted in bad faith during the marriage, they may forfeit their share of the property in favor of children or the innocent spouse. So ang share unta, so for paragraph 51, in said partition, the value of the presumptive legitimacy of all common children computed as of the date of the final judgment of the trial court shall be delivered in cash, property, or sound securities unless the parties by mutual agreement judicially approved had already provided for such matter. So in this article, it addresses the financial implications for common children following the annulment of a marriage. Specifically, it outlines how the value of the presumptive legitimacy or the portion of a child's inheritance that is guaranteed by law for all common children should be handled during the partition of property after annulment. So for Article 52, the judgment of annulment or of absolute nullity of the marriage, the partition and distribution of the properties of the spouses, and the delivery of the children's presumptive legitimacy shall be recorded in the appropriate civil registry and registries of property. Otherwise, the same shall not affect the third persons. So the delivery of the presumptive legitimacy, that is guaranteed share of inheritance for children, must also be documented in these registries. So this ensures that children's rights to their inheritance are protected and recognized legally. So if these documents and distribution are not recorded, they do not affect third parties. So this means that individuals or entities outside the marriage will not be bound by these decisions unless they are officially documented. Now we have the Article 53. So either of the former spouses may marry again after compliance with the requirements of the immediately preceding article. Otherwise, the subsequent marriage shall be null and void. So before either former spouse can remarry, they must ensure that the annulment or declaration of nullity has been officially recorded in the civil registry and relevant property registries. So this step is crucial for establishing their legal status as single individuals. So if a former spouse attempts to remarry without fulfilling these recording requirements, the subsequent marriage will be considered null and void. So for the last article, children conceived or born before the judgment of annulment or absolute nullity of the marriage under Article 36 has become final and executory shall be considered legitimate. Children conceived or born of the subsequent marriage under Article 53 shall likewise be legitimate. Meaning that children conceived or born from a subsequent marriage are also considered legitimate. So this provision ensures that any children born to either former spouse after they remarry are granted still with full legal rights and protections. So that ends my report. Thank you and God bless everyone.